we're waiting on the jail to get ready to call Mr. Corey Butler's case to see more trainers on Zoom.
Yeah.
Okay.
Mr. Trainer, can you see and hear me okay?
Yes, I can, Your Honor. I'm sorry. How are you doing?
Great. This is cause number CR 22-62. Say versus Corey James Butler. Is Mr. Butler still in federal custody?
Yes, Your Honor.
And do we anticipate when he'll be out of federal custody or state still pursuing the state case?
We're waiting on the resolution of the federal case judge to make our decision.
Trainer, do you have any knowledge about when Mr. Butler's federal case may be resolved?
Well, I know that he's set. I believe that there's a plea hearing for him here at the very first part of the month. I think it's August 3rd. Of course, I'm not his attorney on that one, but that's when he should be signing up for his time there.
Okay, then let's reset this. Set this to September. That way, if he does take a plea, then the state is supposed to bench warrant. Are you available on September 19th or 21st, Mr. Trainer?
Hang on 2 seconds, Your Honor. And you said the 21st?
19th or 21st.
Okay, perfect. The and both of those still be in the afternoon, Your Honor?
Yes.
Yeah, so September 21st would be perfect.
All right, court sets Corey James Butler for another status on federal custody. Thursday, September 21st at 1:30. So what I would expect from the state of the defense is if Mr. Butler takes a plea on it's sometime in August, I'm setting it out to September to give y'all time to work out any negotiations that you're going to work out. I don't want to come back on September 21st and be like, well, he's in federal custody. Maybe we're going to get him, maybe we're not going to get him. We don't know.
So, Judge, in federal court, if he accepts a plea in August, he won't be sentenced or judgment imposed until November or December. So we won't have an answer until November or December, unless something happens, there's not guilty somehow. If he's convicted in federal court, the state will not be moving forward in this case. If he's not convicted in federal court for whatever reason, then we would move forward. I see those chances are very slim, but I don't think we will have an answer. I think it's more likely to be November, December.
Even if he takes a plea in August?
Correct. I don't think we will know the outcome until November, December.
So you want to wait until after sentencing time to select the plea?
Yes, Judge.
Okay. Then I'll tell you what I'm gonna do. I'm gonna set up one final status. We'll set it for January 24 docket. Let's set it for are you available Thursday, December 14th, Mr. Trainer?
I'm sure, yes, sir.
Okay, what I'm gonna do is I'm gonna set it for December 14th. That'll be at 1:30. And I'd like to know on that day whether we're keeping it or not. Otherwise, it's just gonna been riding the dog way too long. All right, Mr. Trainer, we'll see you back on December 14th.
All right, thanks very much, Your Honor.
Mr. Schmidt, are you ready to jump?
What you call me? Oh, okay. Yes, we're ready. Thank you.
All right, who are you ready on?
Jeremy Ward.
All right, Jeremy Ward, CR 18385, CR 18384. Mr. Ward, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, lawyer again, make sure you speak up loudly and clearly for me. Counsel, correct me if I'm wrong, today is a plea on the motion to revoke. And that would be a plea and it calls for 385 with. What's the disposition of 384? I don't have anything. 384.
It's a plea also, Judge. We forwarded those papers out to the jail.
We have those and are prepared on both.
Okay, so I don't have 384, so tell me what the terms are on 384.
On a plea of true, the state's recommending that Mr. Ward's community supervision be revoked, that he be assessed 3 years confinement in TDC or to pay the balance of his financial obligations. The balances on 384 are $2,000 in fines, $459 in court costs, 270 days credit towards that sentence.
Give me a second. Pull up these three. All right, Mr. Ward, in cause number CR 18384, you appeared before the court on November 8th, 2018. You pled guilty to injury of a child or elderly or disabled individual, a third-degree felony. Court heard the plea agreement between you and the state. The court followed the plea agreement. Court convicted you of that offense, such your sentence at 10 years confinement in prison. Court suspended that sentence, placed you on 5 years of community supervision, and ordered you to pay a $2,000 fine. And that's the same thing happened in cause number CR 18385 on the third-degree felony offense of continuous violence against the family. And it was during your period of community supervision that the state filed amended motions to revoke in each case. And in cause number CR 18384, they alleged 6 separate counts of allegations, and in cause number CR 18385, they alleged 5 counts of various allegations. So, Mr. Ward, have you had enough time to talk with your attorney, Mr. Schmidt, about these 2 motions?
Yes, sir.
Are you happy with the work that he's done for you as your attorney?
Yes, sir.
Do you understand everything that you've read and signed today?
Yes, sir.
Mr. Schmidt, do you believe Mr. Ward's competence in entering into the agreements with the state?
I do.
And does your client intend to plead true to all counts in both motions?
Yes, sir.
All right, Mr. Ward, then in cause number CR 18-00384 as to counts 1 through 6, how do you plead to those counts?
Guilty. Oh, sure.
And in cause number CR 18385, how do you plead to counts 1 through 5? Are those counts true or not true?
True.
Are you pleading true to each of the counts, each case, because all of the counts that are alleged are in fact true?
Yes.
Has anyone threatened or forced you to plead true to any counts today?
No.
And Mr. Ward, I see that the plea agreement is that the state's recommending that you be that your community supervision be revoked today and your sentence be assessed at 3 years confinement in prison, with you being ordered to pay the balance of your financial obligations, your fines, court costs, those things. and that your sentences will run concurrent with each other. Is that your understanding of the plea agreement? Sorry, I didn't hear you.
Yes.
Okay, all right, then, Mr. Schmidt, is there any objections to the admission of the defendant's waiver of rights to plea true in each case?
No objection.
All right, then the court will accept Mr. Jeremy Ron Ward's plea of true to each motion to revoke. Court also admits the defendant's waiver of rights to plea of true into evidence, takes judicial notice of his judicial confession. Is there anything further from the state
No, Your Honor.
or from the defense?
No, sir.
All right, then cause number CR 18-384 and CR 18-385. Court finds that Mr. Jeremy Ron Ward has violated the terms and conditions of his community supervision. The court revokes his community supervision. And the court assesses punishment. Each case had 3 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay the balance of his financial obligations. Mr. Schmidt, how much credit time does Mr. Ward have in cause number 384?
270 days, Judge.
Court will award Mr. Ward 270 days credit towards each sentence for the time that he has spent in jail on this cause. Mr. Ward, you hereby remain into the custody of the sheriff so he can carry out the terms and conditions of this. Please step over with the deputy and briefing. Are you ready on this?
It's Brad Rodriguez, CR 20-269.
All right, Mr. Rodriguez, if you'll raise your right hand, I'm gonna place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, lower your hand. Mr. Rodriguez, you also appeared before the court on March 4th of 2021. You pled guilty to aggravated assault with a deadly weapon, a second-degree felony. Court followed the plea agreement that you reached with the state. Court deferred a finding of guilt, placed you on 10 years community supervision, ordered you to pay a $3,500 fine. It was during your probation that the state filed a motion to adjudicate and revoke on March 1st, 2023. Have you had enough time to talk about your case with Mr. Schmidt?
Yes, sir.
Are you pleased with his work for you as an attorney?
Yes, sir.
You feel like you've had enough time to read over all this paperwork, and you understand everything that you've read and saw?
Yes, sir.
Mr. Schmidt, you believe Mr. Rodriguez to be competent?
I do.
And does he intend to plead true to all counts, which are 9 counts alleged in the motion?
Yes, sir.
All right, and Mr. Rodriguez, I see the plea agreement today is upon your plea of true, the state's recommending that your guilt be adjudicated. That means for you to be convicted of that aggravated assault with a deadly weapon, that your community supervision be revoked, and that you be sent to prison for 4 years, and you would pay the balance of your fines, court costs, and reimbursement fees, and you would receive 414 days credit towards your sentence. Is that your understanding of the plea?
Yes, sir.
All right, then, Mr. Rodriguez, how do you plead to counts 1 through 9 as alleged in the state's motion? Are those counts true or not true?
True.
Has anybody threatened, force, or pressured you to plead true?
No, sir.
The court accepts Mr. Rodriguez's plea of true to all counts alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights to plea of true?
No objection.
That is admitted. Court takes judicial notice of Mr. Rodriguez's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No, sir.
All right, then, Mr. Rodriguez, based on your plea of true and the evidence before the court, I find that you have violated the terms and conditions of your community supervision. Court will follow the agreement today. The court adjudicates your guilt, convicts you of aggravated assault, deadly weapon, a second-degree felony. Court finds that there is a deadly weapon used, however, it was not a firearm. The court hereby assesses your sentence at 4 years confinement in the Texas Department of Criminal Justice. orders you to pay the balance of your fine or cost of reimbursement fees. And the court awards you 414 days credit towards your sentence for the time that you've spent in jail on this cause. Mr. Rodriguez, you hereby remanded to the custody of the sheriff, so he can carry out the terms and conditions of the sentence. Please step over to the deputy to be fingered. Who's next, Mr. Smith?
Misty Rice, CR 2133.
Ms. Rice, the plea today at all?
Yes, sir.
All right, Ms. Rice, you'll raise your right hand. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God. Okay, I saw you, I couldn't hear you though.
Sorry, I didn't. Yes.
I don't know if it's just because you're quiet or because there's issues with the computer, but make sure you speak up loudly and clearly. All right, Ms. Rice, you also appeared before the court on December 14th of 2021. And you pled guilty to possession of a controlled substance, a class A misdemeanor. Your punishment was assessed at 1 year in the county jail. The court was suspended. You were placed on probation for 2 years, ordered to pay a fine. During your probationary period, the state filed a motion to revoke your community supervision and alleged appears to be 10 separate counts of violations. Have you had enough time to review this motion with your attorney, Mr. Schmidt?
Yes, sir.
Pleased with Mr. Schmidt and his work,
Yes, sir.
and you feel like you understand everything that you've read over and signed today with them, is that correct?
Yes, sir.
All right, Mr. Schmidt, do you believe Ms. Rice to be competent
I do.
and she intends to be true to all counts?
Yes, sir.
All right, and Ms. Rice, I see the plea agreement is that upon your plea of true, the state's recommending that your supervision be revoked. Your punishment be assessed at 60 days confinement in county jail. You would receive 29 days credit towards that sentence for time already served. You'd be ordered to pay the balance of your fines, court costs, and reimbursement. Is that your understanding of the plea agreement, Ms. Rice? Say again.
Yes, sir.
Okay. All right, then Ms. Rice, how do you plead to counts 1 through 10 as alleged?
True.
For all, and you're telling me that all 10 counts that you're pleading true to, all of those are true, and you're not telling me they're true just so you can get a plea agreement, is that correct?
Yes, sir.
Has anyone threatened or forced you to plead true to any of these counts?
No, sir.
All right, court accepts Ms. Rice's plea of true to all counts. Mr. Schmidt, any objection to the admission of the defendant's favor of rights and plea of truth?
No objection.
That's admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state
Nothing.
or the defense?
No, sir.
All right, and based on the evidence, court finds that Misty Michelle Rice has violated the terms and conditions of her community supervision. Court will follow the plea agreement today. Court hereby revokes her community supervision. Assesses her punishment at 60 days confinement in the Van Zandt County Jail for the Class A misdemeanor offense of possession of a controlled substance. Court awards her 29 days credit towards her sentence for the time that she spent in jail. Previously on this charge, court orders her to pay the balance of the financial obligations, including fines, court costs, and reimbursements. And Ms. Rice, once you get out of jail, you need to show up over at the courthouse and make arrangements to pay off your fine, court costs, and reimbursements. Failure to do so, and were to follow the payment plan that will be extended to you, if you can't pay them all, will result in the court issuing a warrant for your arrest. We'll go right back to this old scenario again, you understand?
Yes, sir.
Okay. All right, Ms. Rice, you hereby remanded to the custody of the sheriff, so you can carry out the terms and conditions of the sentence. Please step over the deputy to be here. Who's next, Mr. Schmidt?
Michael Shane Covey.
All right, this is cause number CR 21-54. And what's the announcement on Mr. Covey?
Judge, we have reached an agreement with the state wherein the state has agreed to withdraw their motion to revoke and continue Mr. Covey on community supervision with the following amendments. That he serve 180 days in the county jail as a condition, which roughly his time served And he is to be assigned to the mental health caseload and assessed new attorney's fees.
And how long is Mr. Covey's probationary period originally?
I don't recall right off the top of my head, Judge. I can pull it up. You know, 2031 is when he expires, apparently.
And probation is supportive of this continuation on probation.
Yes, sir.
He said yes.
Okay, Mr. Covey, raise your right hand. I'm gonna place you under oath. Mr. Covey, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, good Lord, again. Mr. Covey, has anyone threatened, forced, or pressured you to make you feel like you had to enter into an agreement today?
No, sir.
You understand that at addition of community supervision, these 180 days that are being ordered, you understand that if you receive another motion to revoke and you are subsequently revoked and sentenced to prison, you would not get credit for these 180 days. You understand that?
Yes, sir.
All right, and Mr. Covey, tell me why I should put you back on probation. Why shouldn't I just have a hearing and put you in prison today?
Well, Your Honor, really had a really rough time with my mental status. I've been in and out of mental institutions. Whenever I got out, I did a little bit of time going to Terrell, in and out of Terrell, and just roughly got out maybe a couple of weeks before I actually got picked up on my warrant. So my time's been kind of hard, and I haven't actually had the footstool that I need to jump back on the wagon. And this right here gives me the ample opportunity to jump back on the wagon and to carry on with my life and to proceed with going on with what I stated about getting a job. You know, just getting my life back on track.
Is it gonna be different this time on probation?
I sure hope so.
Well, that makes two of us.
Yes, sir.
Because the next time you come back in, you may not get the same opportunity that you got today. You understand?
Yes, sir. I do understand.
All right, I want to make sure we're on the same page.
Yes, sir.
All right, the court will grant the state's motion to withdraw the motion to revoke, adjudicate. The court will amend the community supervision conditions to include 180 days as a condition of community supervision. Will issue him credit for any time previously served towards that 180 days. Court will order him to be placed on the mental health caseload and order him to pay reimbursements to Payne County for attorney fees. All right. Step over and talk with the probation officers. Who's next?
Bryce, Carol.
All right, this is cause number CR 21208, State versus Bryce Christopher Carroll. Go ahead, Mr. Schmidt.
Judge, we reached an agreement with the state where the states agreed to withdraw their motion to adjudicate to continue Mr. Carroll in community supervision, to modify his terms of supervision so that he serves 144 days in the county jail as a condition, and assesses additional $500 in attorney's fees.
All right, Mr. Carroll, raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, glory again. All right, Mr. Carroll, you know what I'm gonna ask, don't you?
Yes, sir.
What am I gonna ask?
Why should I be here instead?
I've always thought you were a smart individual, and I never understood why you can't stay out of court. I mean, I've pleaded with you, pleaded with you, over and over and over, all the way back to when this court was having to go to Bulls Point and your stepdad was at the courtroom. We went through this song and dance over and over and over. And I really had high hopes for you. I spent a lot of time lecturing you because I didn't want to see you in a jumpsuit doing this. So tell me, why should I go against my gut here?
I've done a lot of maturing over the few months I've been here. This is the longest time I've been away from my family, so I know that they feel like they deserve better. They will see me in these orange jumpsuits.
Last chance. Is it? Don't come back in front of me and ask for anything else.
Yes, sir.
I'm tired. I don't want to be a man that says, hey, you're gonna do this, and there's gonna be consequences. And then you go do it and you come back and there's no consequences. It drives me crazy. But I guess I'm gonna do that. Yeah, you've got somewhat of a consequence of having 144 days is a long time to be sitting in jail.
So it is.
If that doesn't teach you your lesson, then I guess it doesn't matter how long the prison sentence is, it won't teach you either. All right, so I'm through talking, all right? All I wanna do is see actions. I don't wanna hear you telling me what you're gonna do. I wanna see you doing it. All right, and if you don't do it, then don't come in here and say anything else to me. Come in here and face the music. Do what you said you were gonna do a couple of years ago. You understand?
Yes, sir.
All right, court's gonna grant the state's motion to withdraw its motion to adjudicate. Court's gonna amend the community supervision conditions to include 144 days in county jail. And we'll give him credit for those times for the dates outlined in the state's motion. Court also ordered him to pay new attorney fees of $500. Court continues Mr. Carroll on community supervision. Step over and talk to the probation officers.
Your Honor,
Yes, ma'am.
do you see the February?
Yes, the interpreter is.
Your Honor, we still show Chinese.
I know, yeah, give me a second. It takes me a second. All that. Change. Great, all right, this is. This is cause number CR 23-00028. State versus Felix Alejandro Vasquez Diaz. Felix, if you can raise your right hand and go ahead and state your name and your license for the record. All right, Ms. Bill, do you swear? Ms. Bill, do you solemnly swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial, to the best of your skill and judgment? So help you God. All right, thank you. All right, Mr. You can go ahead and put your hand down, Mr. Diaz. All right, Mr. Alton, go ahead.
Your Honor, we have a plea agreement in this cause. I've had Mr. Diaz execute the documents. Obviously, I can't get the state to sign on at the moment.
All right, you got to speak up a little bit for me. I think I heard most of it, but I don't know if the court reported it. So, all right, Mr. Vasquez, This is. Plea agreement appears to be that you would plead guilty to the third-degree felony offense of evading arrest or detention of a vehicle. State's recommendation is that the court defer a finding of guilt, place you on 3 years of community supervision, a $1,000 fine, $290 of court costs, $535 reimbursement fees, and the state would be dismissing a resisting arrest and also a criminal trespass. Is that your understanding of the plea agreement, state? Can I ask, is the defendant's last name Vasquez or Diaz?
Those goals? Yes.
Should it be styled Felix Alejandro Vasquez Diaz?
No, it's Revocation.
Felix Alejandro Vasquez Diaz?
No, Diaz Vasquez.
Okay. All right, Mr. Diaz Vasquez, the range of punishment for a third-degree felony offense, such as evading arrest or detention of vehicle, if convicted, would be not less than 2 years in prison or more than 10 years in prison, and a fine which cannot exceed $10,000. Mr. Alton, do you believe that Mr. Diaz Vasquez is competent to enter into this plea agreement?
I do, Your Honor.
And remind me about Mr. Diaz Vasquez's legal status in this country. My recollection is that he is not a citizen. And then you've addressed that with the court and the defendant about possible consequences if he should plead guilty today. And the court should make any kind of order regarding deferred adjudication. Is that correct?
Yes, Your Honor. By my understanding, we're speaking with Mr. Diaz is that he is not a citizen. However, the state approached and said they had found prior in prior cases that he was. So at this point, I'm unaware of whether he's a citizen, whether he's not. I have advised him as if he's not a citizen and explained to him that this plea could have negative consequences as far as immigration or nationalization is concerned. And so he's been advised of the potential issues that this plea could cause, but he also understands the positives of the plea in this particular agreement.
Great.
Your Honor, the defense criminal history shows that he was born in the US and was a citizen. It was our impression that Mr. Alton had confirmed that with his clients. If he has not confirmed that, we cannot offer probation because he will immediately be in violation if he's here without documentation. So if Mr. Alton's position is he doesn't know if his client's a citizen, then we can't go forward with this plea, Judge.
Joel, address that.
Yes, Your Honor, that plea agreement was offered before the state had even told me that they were under the impression that he was a citizen, and after I had announced that he was undocumented. To my recollection, if the state believes I'm remembering that incorrectly, then maybe I am.
Ms. Curry is indicating that his criminal history states that he was born in the United States. So have you had those discussions with your client?
I've asked him if he was a United States citizen, and he indicated that he was not, as well as the family member that he allowed to translate for whenever we spoke when he was on the outside, not incarcerated. And they believe that he was not a citizen as well. I guess we could hear from Mr. Diaz again if he was born or was not born in the United States.
Do we have any issues with the criminal history not being the correct individual? Have we confirmed with identifiers or PIDs or SIDs.
If they they match, Your Honor, however, you know, could be stopped at something said was a citizen. The identifiers appear to match, Your Honor. However, I've seen it happen before. That's why we asked Mr. Alton to try to ask his client to get to the bottom of it. Frequently, if an individual without documentation is encountered by law enforcement and they answer the question, are you a citizen? Yes, then that gets put on the record by law enforcement without any way to verify or not verify.
So what I'm hearing is that Mr. Alton believes that the defendant, based on the conversations he's had with the defendant and the defendant's family, is that he is not a United States citizen. The state's telling me that this offer of 3 deferred was contingent on him being a United States citizen.
Which is, today is the first time I've heard that, Your Honor. If Mr. Diaz may not understand that he was born in the United States, that he is a United States citizen, I never asked him the question, were you born in the United States? I asked him, are you a citizen or are you undocumented, or do you have a green card?
All right, let's go ahead and ask him those questions right now. Go ahead and just remember, Mr. Alton, that this bill is assisting us. Make sure you speak up loudly and clearly so she can hear.
Mr. Diaz, could you state your full name for the record in the correct order?
Félix Alejandro Díaz Vázquez,
And where were you born?
en México,
And where at it?
Guanajuato.
Guanajuato?
Sí,
Not born in the United States.
no,
And have you been found to be a naturalized American citizen at any point prior to today?
mm, sí,
When was that?
en este año, en febrero.
I can't hear the answer to that question. I can't hear the interpreter.
I believe she said yes this year in February.
Was it an immigration judge that gave you citizenship?
No, apenas apenas van a ver eso del 2024.
I can't hear the interpreter at all, Your Honor. So I don't know how to ask the next question because I don't know what his answer was.
Is there an audio problem there in the jail? Can y'all turn up the volume over there, please?
I can hear you perfectly fine.
We don't.
No, don't unmute that. That one, the laptop needs to stay in the Spanish channel. That's the only way that he's gonna be able to hear. What we're viewing you on is a separate computer system. It's in the English channel. So he's only being able to hear through his headset and speak through his headset. Everyone else is in the English channel. And they should be able to hear me. You're hearing me, Ms. Abraham?
We hear you, but we do not hear Miss Mill.
Okay, then on the jail computer, not the one in front of you, not that one, but this other one, make sure that you're in the English channel. Because if it's in off, you're not able to hear her. It says manage language interpretation.
We can hear you now.
Thank you, Ms. Bill, you were right. Okay, so, I believe the last thing you said, you asked whether or not an immigration judge had granted him his citizenship. Do you recall that testimony, Ms. Bill? All right, go ahead, Mr. Johnson. Ask that question again.
Did an immigration judge or some other administrative court declare you a United States citizen?
No, una respuesta hasta el 2024.
Okay, so have you been labeled a permanent resident or anything else like that?
Tengo unos papeles en mi casa que me dieron, pero no sé.
Okay, so what I'm gonna do is I'm gonna intercede here and I'm gonna say that we're gonna reset this case. We're not gonna go forward with a plea. We're gonna give Mr. Diaz Vasquez an opportunity to maybe have his family members bring in that paperwork to Mr. Altum. We can figure out what the issue is. If Mr. Diaz Vasquez is not a citizen, as he's indicating, state's indicating that he's either withdrawing that plea or cannot make the plea offer of deferred community supervision. We certainly don't want to put somebody on deferred community supervision with a language barrier who doesn't have citizenship in the country that could result in immediate deportation. So we're going to reset this case. Mr. Alton, can you come back on? Can you come back on August 4th, Mr. Alton?
August 4th,
24th.
24th. I'm having back surgery on August 7th. I'm gonna be out for at least 8 weeks.
9 weeks.
8.
8.
If you need to reappoint someone who's more available, I mean, the defendant with a deferred offer, if we find out he has some sort of permanent residency, I don't think he needs to sit just because I'm laid up from a surgery. Yeah, won't even bill for it.
All right, of course, going to reset Mr. Diaz Vasquez to August 24th. And I'll take that under consideration, Mr. Alton.
Okay.
But in the meantime, though,
I will work on getting those documents from his family.
okay, that's what I was gonna ask. Ask Ms. Beal, can you ask Mr. Diaz Vasquez if he has any questions or if he understands what's going on?
Sí, no, mira, está bien.
Okay, does he understand why we're resetting the case today to check on the status?
Sí.
Okay, then, Mr. Diaz Vasquez, I may have to appoint another attorney to you because Mr. Alton may not be available at our next hearing. So if I do that, someone else will have to come and meet with you and work on your case. And if that happens, we'll notify you.
Okay.
Okay, all right, then, Mr. Alton, if you'll sign that notice setting with Mr. Diaz Vasquez for August 24th, then I'll move on to the next case.
Thank you, Your Honor.
Your Honor, before you let Miss Bill leave, can I say something?
Yes.
Mr. Smith has one that speaks Spanish that needs an arraignment. Do you have time, Miss Bill, to do that? Should take about 5 more minutes. Thank you.
All right, Ms. Bill, let me give you some information on the case.
And it's on Mr. Sosa.
All right, so this bill is going to be cause number CR 23-00132. First name Josue, Josue. Last name Sosa, Sosa. And today will be for number 3. I'm only going to let you establish communication, Mr. Sosa. And Ms. Abraham, can y'all turn on the video there for Mr. Sosa so he can look at this bill and see his face on the laptop and start? So she can see him, they help her. That's what's now means to me. All right, this is cause number CR 23-132, State versus Josue Sosa. The court is using the assistance of Ms. Holly Beal, a licensed court interpreter. She has already been placed under oath on this docket. And Mr. Schmidt, you've been appointed to represent Mr. Sosa, and we're set for arraignment today. Have you had an opportunity to go over the indictment with Mr. Sosa, or do you need the assistance of Ms. Bill to do that?
Judge, I have met with Mr. Sosa with an interpreter and we have some communication, although limited. He has not seen the actual indictment. So he understands what he's charged with, but if we could put the indictment up and we intend to waive formal reading, but and enter a plea of not guilty.
Okay, stand by.
And Judge, Mr. Sosa has informed me that his name is laid out correctly. I think the technicalities of the charge, he understands he's charged with theft. If I could have the interpreter explain to him that the range of punishment is 2 years to 10 years in the Texas Department of Criminal Justice Institution Division. Once that happens, we would waive formal reading of the letter of the indictment and plead not guilty.
All right, did you do that, Ms. Bill? Did you explain to Mr. Sosa the range of punishment? Thank you. All right, then the court will find that Mr. Sosa has waived the formal requirements of arraignment, waived the formal reading of the indictment. Court will enter his plea of not guilty into the record. We'll set this matter for pretrial hearing. Starting in September for now. September 19th. Be available then, Mr. Schmidt.
Please, so is that a Tuesday, Judge?
Yes, sir.
Yes, that's fine.
All right, Mr. Sosa, we'll see you back on September 19th. If you're still in jail, your hearing will be at 1:30. If you make bail on the case, then your hearing will be on the same date. It'll just be at 9 a.m. Ms. Bill, if you can ask Mr. Sosa if he has any questions for his attorney or for the court that we can address.
Está bien.
All right, and we'll see everyone back on September 19th. Ms. Bill, thank you for sticking around and taking one more for us. Yes, ma'am, have a great day. All right, Mr. Chairman, who are you ready on?
This is Michael Bowman.
Did you say Huddleston?
Bowman.
All right, this is cause number CR 23-5. State versus Michael Dwayne Bowman for pretrial. Go ahead, Mr. Schmidt.
Judge, we're gonna ask for an additional pretrial setting. I need to have an opportunity to look at the videos with Mr. Bowman. If that's all right.
All right, then court will reset the additional pretrial for September 19th. 1:30.
Thank you, Judge. Yeah.
All right, who do you have then?
Judge, we're ready on a plea. Mr. Rayco.
All right, this is cause number CR 21-90, and it's pronounced Rayco. Is that correct?
That's correct, Judge.
All right, State versus Cannon Nash Rayco. Mr. Rayco, if you will raise your right hand, I'm gonna place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. Come over here. All right, Mr. Rayco, you appeared before the court on August 25th, 2022. You pled guilty to injury to a child, elderly, or disabled individual, a third-degree felony. Court heard the evidence, followed a plea agreement that you reached with the state. Court assessed your punishment at 4 years confinement in TDCJ and ordered a $3,000 fine. The court then suspended that sentence, placed you on 3 years community supervision. It was during that period that the state filed its motion to revoke. And in doing so, they alleged 3 separate counts of violations. Have you had enough time to review that motion with your attorney, Mr. Jonathan Manning?
Yes, sir.
Are you pleased with Mr. Manning and the work he's done for you?
Absolutely.
Do you have any questions about anything that you've read over and signed today?
No, Your Honor.
And where you sign that your true and correct signature and you understand everything you signed?
Yes, sir.
All right, Mr. Manning, do you believe Mr. Rayco to be competent to enter into the plea agreement?
I do, Judge.
And I see that the plea agreement is that he's going to plead true to all counts. State's recommendation is revoke his community supervision, assess his punishment at 3 years in prison, and order him to pay the balance of his financial obligations.
That's correct, Judge. Additionally, he has 388 days credit.
Correct. Okay. All right, Mr. Rayco, then let me ask you, how do you plead to counts 1, 2, and 3 as alleged? Are those counts true or not true?
They're true.
And you're telling me that each one of those counts are true because, in fact, it is true what they've alleged. You're not just saying that to get a plea agreement. Is that correct?
Sir.
All right, the court will accept Mr. Rayco's plea of true. Mr. Manning, any objection to the admission of the defendant's waiver of rights, plea of true?
No objection.
That's admitted, and the court takes judicial notice of Mr. Rayco's judicial confession. Anything further from state?
No, Your
For the defense?
Nothing from defense, Judge.
All right, then based on the evidence presented to the court and Mr. Rayco's pleas of true, the court finds that Mr. Rayco has violated the terms and conditions of his community supervision. The court will follow the plea agreement today. The court hereby revokes the defendant's community supervision, assesses his punishment at 3 years confinement. The Texas Department of Criminal Justice orders him to pay the balance of his financial obligations. The court awards him 388 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Rayco, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. When you get out of prison, you need to report to the courthouse and pay off what you owe. And if you can't do that, then we will enter into a payment plan with you. And if you don't honor that, the court will issue a warrant for your arrest. You understand?
Yes, sir.
All right, please step over to the deputy. Mr. Manning, are you ready on now?
Judge, ready on Michael Ray Huddleston?
All right, this is cause number CR 23136, State versus Michael Ray Huddleston Jr.
Judge, this case was filed by information here this week. We have executed a waiver of indictment and are ready to proceed on the information for this charge.
Okay, thank you. All right, Mr. Huddleston. I already placed you under oath. Have I placed you under oath, Mr. Huddleston?
Not at this time, no, sir.
You'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Your name is Michael Ray Huddleston Jr., is that correct?
Yes, sir.
Now, I noticed the paperwork says Michael Ray Jr. Huddleston, but that's not correct, is it?
No, sir.
Is that what y'all's paperwork says?
That, I just noticed that, Judge, and that is incorrect.
So what I may do is white out may modify the judgment to just say Michael Ray Huddleston and write it. Actually, I'm gonna ask the state to correct that because I'm not sure if that's gonna be a problem with TBC or not. Yes, sir. Could be. We just get, just for the judgment, I'm not worried about the rest of it. All right, Mr. Huddleston, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work that he's done for you?
Yes, sir.
Feel like you've had enough time to talk with him about your case, you've had all of your legal questions answered,
Yes, sir.
and where you have signed today, you're telling me that you're signing because you've read through this and you understand what you're signing.
Yes, sir.
And Mr. Manning has also indicated that you have waived your right to an indictment in this case, is that correct?
Yes, sir.
And Mr. Manning, do you have the waiver of indictment there with you, Mr. Huddleston?
We do, Judge.
And so, Mr. Huddleston, you do understand that no one in Texas can be prosecuted for a felony offense without the grand jury issuing a true bill of indictment after reviewing it and finding that there's probable cause to believe that the person has committed the offense. And that is a right guaranteed to you and all other individuals under the Texas Constitution. You understand that?
Yes, sir.
Now, you can waive that right as long as you're doing so intentionally, knowingly, and voluntarily. Is that what you're doing today?
Believe so.
Okay, you understand that you're waiving your right to have your case presented to the grand jury, and you're allowing the state to move forward with prosecuting based on them filing an information. Basically, they're filing a legal document with the court. They're not going to the grand jury. You understand that?
Yes, sir.
And if the court approves your waiver of indictment, you can't later say, hey, I want to be indicted now. Understand that?
Yes, sir.
It's a right that what you give up is not going to be restored to you. Understand that?
Yes, sir.
And has anybody threatened you, forced you, or pressured you to give up your right to indict?
No, sir.
All right. And Mr. Manning, you've counseled Mr. Huddleston on his right to indict, what the waiver entails.
I have, Judge, and he has executed the same waiver of indictment today.
Court will find that Mr. Huddleston has been admonished as to his right to indictment, has waived the same intentionally and voluntarily. All right, Mr. Huddleston, you are charged by information with the third-degree felony offense of violation of a bond or protective order 2 times within 12 months. A third-degree felony carries a range of punishment of not less than 2 years in prison or more than 10 years in prison. In carries a fine not to exceed $10,000. That means if the court follows your plea agreement today, which is the state's recommending that the court not convict you today, but place you on deferred adjudication, which means the court would place you on community supervision for 8 years, order you to pay fines, court costs, reimbursement fees, and the state's going to be dismissing another violation of bond or protective order, and obstruction or retaliation, another violation of bond or protective order, assault causes bodily injury, another violation of bond or protective order, and a criminal mischief. They would be dismissing all of those in connection with your plea agreement today. If the court honors that and places you on community supervision, if you violate any of the terms and conditions of your community supervision, the state can file a motion to adjudicate your guilt. That means to convict you, to bring you back to the court. And if the court finds that you have violated any of the terms of your probation or community supervision, the court could do a number of things, including convicting you of the offense, moving you from community supervision, and assessing your punishment anywhere from the minimum 2 years all the way to the maximum of 10 years. Do you understand that?
Yes, sir.
I'm understanding that you still wish to go forward.
Yes, sir.
All right, then, Mr. Huddleston, this time, how do you plead to a third-degree felony offense of violation of the bond or protective order 2 times within the last 12 months?
True. Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened or forced you to plead guilty today?
No, sir.
All right, the court will accept the defendant's plea of guilt. Mr. Manning, any objections to the stipulation of evidence?
No objection to states one stipulation.
All right, then the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
Is there any victim concern, victim compliance, victim supportive of this plea? While the state's looking that up, I don't have conditions of community supervision. Mr. Manning, do you have those with you?
I do, Judge.
Is there a condition in there that provides that you not have any contact with Jessica Huddleston?
Judge, I did not see that in the conditions of probation, but I was doing a couple different things when I was going over that. So let me check and double check and make sure. I do not see that in the conditions, Judge. The probation department was saying they did not receive that as part of the referral. I do know this, Judge, that they share at least one child together. And so whatever conditions of contact would have to be in accordance to the family law rules regarding his contact for his daughter.
Is there any existing family law orders regarding the possession, conservatorship, or access to the child?
Judge, I've discussed that with my client, but let me sit back and make sure that my recollection is correct.
No.
Judge, my client has informed me that there was a suit filed for divorce, but it has not been finalized, and it is his belief that there are not currently temporary orders pending as to possession and access of the child at this point.
Do any of the protective orders or bond conditions alleged in any of the matters for today affect his ability to be in or around any child subject to protective order?
No, she was not a part of any of the cases that are listed. And she currently, her residence was with my client before he was placed in custody.
She still lives there. 60. Wait. My steps.
Here's that Mrs. Huddleston filed an original petition for divorce in April of 2023. And that's currently in county court of law. It does not appear that Mr. Huddleston's been served with that. So court found that there are no finding, that there are no temporary orders pending at this time. State's still looking to see if there's any victim.
Your Honor, with regard to the property crimes cases that are being 1245, the victim did not respond to our letter requesting restitution information for those offenses. And surprisingly, Judge, I learned from this case that violation of bond or protective order is not an offense that the statute recognizes as one, allowing for a BIS or allowing for allocation or anything like that. So we are in compliance.
But is there any concern from the DA's office that Ms. Huddleston would not be supportive of him being placed on deferred supervision by this court?
We have no information that she would be.
Mr. Manning, in order for me to approve this plea, there's going to have to be a community supervision condition that tracks that of the protective order regarding no contact with Ms. Huddleston in a threatening or harassing manner. What I don't want to do is put him on community supervision with no condition regarding not being able to contact her.
Understand, Judge. I don't anticipate that be a problem, as it was not part of our negotiated agreement. I need to speak to my client about that, what that would entail. I will note for the court that the contact that was alleged in the violation of protective order was not all of it was not threatening or harassing. It was just simple contacting, and that while that is a violation of the law and of the protective order, it was not of the harassing or threatening nature. So let me speak to my client about that condition, and we'll let the court know.
Okay.
Judge, my client understands that he points out and is correct that he's currently under those conditions with the protective order. I explained to him that would extend for the entirety of his probation, which is 8 years, and he is all right with continuing that.
So we're going to take the language out of the protective order and we're going to place it in as a condition of supervision.
Judge, if I may, before it's signed off on, if I can just take a look at that. I haven't looked at his protective order in a while since I first got the case. So if I may take a look at that language before we sign off on it, but yes, that would, I would imagine, suffice.
Do you want me to recall it later this afternoon, or do you want to reset today? Or what?
Judge, I have a contested issue there this afternoon.
Let's just bring Mr. Huddleston over at that time too, then.
Okay, that'll work, Judge.
That'll give us time to work through it, and I can look at the protective order myself and tell you what the language is.
Yes, Judge, I appreciate it.
All right, Mr. Huddleston, we're going to bring you over to the courtroom later and we'll finish up your case.
Okay, thank you, sir.
Abraham, can you you amend the transport list to include Mr. Post, please? Mr. Rain, you ready on anyone else?
Yes, Judge, ready on Mr. Richard Ozuna.
Mr. Ozuna, CR 22-385, CR 22-282 for retrial. Go ahead, Mr. Rain.
Yes, Judge, I had an opportunity to go over the discovery or the new discovery in the new case with my client at this time. I believe there's a couple things that were still outstanding, but there's nothing I think that will be leading to a contested evidentiary issue. I would request we be reset for docket call. Additionally, Judge, if there is anything that comes up through the discovery process or is brought forth, I just ask that we be allowed to file motions at that point in time if it becomes so necessary.
Court will entertain a motion. Obviously, I think the law still requires you to show good cause, those things, but of course the court will consider it. Let's set Mr. Ozuna for Thursday, September 21st. Dr. Paul. Mr. White, once I complete the jail docket, then I'm gonna call your case first. As soon as we get through this few more. Anyone else, Mr. Manning?
Judge, I'm supposed to have Mr. Randy Young. I don't see him in here. I think he's in the kitchen as a trustee. Would you like for me to wait for him or come on out to the courthouse and just announce from there?
Let's ask somebody in the jail staff to summon him. I call some other cases while we're waiting on him.
Yes, Judge.
All right, this is cause number CR 21-92, State versus Glen Allen Smith. Is Mr. Smith in the courtroom at all?
Sorry. Yes, he's here.
Come on up, Mr. Smith. All right, Mr. Smith, your attorney, Mr. Dahman, had a family medical emergency. I'm not sure if you're aware of that. Are you aware of that?
Yes, sir.
Okay, yes, I believe that his wife had a major medical issue. And so he's unavailable and unable to be here today. So he's asked to reset your case. So the court's granted that for Mr. Dahman. I'm going to reset it to August 24th, okay?
Sorry.
All right, and I'm sure he'll be in contact with you soon. But it's something that just happened very recently.
Oh, okay.
All right.
Thanks, sir.
You're welcome. Mr. Abraham, is Mr. Lowe over there with Mr. West?
Yes, Your Honor.
I'll call him.
Yes, ma'am.
Sorry. Sorry, you're good.
All right, it's cause number CR 23-81, State versus Daniel Keith West.
Yes, sir.
Good afternoon, Mr. Lowe.
Sure.
All right, I believe we're set for pre-trial today. Any contested pre-trial issues? Do you have all the discovery?
Well, actually, plea papers that we're ready to plead. I can bring the court up to date. We had, the court granted the order for a competency evaluation. That report came back and it was determined by the psychologist that Mr. West was in fact competent about. When I first appointed, I had a good faith belief that he was not competent But over the course of his incarceration for the last 201 days, he's been medicated, been seen by a psychiatrist from anyway, he's been seen by psychiatrist, Andrew Center. Andrew Center, he's on 3 or 4 medications now. 4 medications, but I believe that he is competent and does understand the consequences of plea of guilty. So we do have plea papers where he's going to plead guilty to the burglary of habitation second-degree felony. 5 years for probated for 5 years. He does have some jail credit. He has conditions of probation and he's reviewed those. I would ask that he be placed on the mental health caseload because I think that it's going to be a day-to-day thing for him, and he needs somebody that's experienced with that level of problem to supervise.
All right, Mr. West, you'll raise your right hand. I'm going to place you under oath. Mr. West, do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, Mr. West, you lower your hand. Mr. West, your name is Daniel Keith West, is that correct?
Yes, sir.
And Mr. West, you have been diagnosed with mental health conditions, haven't you?
Yes, sir.
And you're currently being medicated or under the treatment of a doctor or care of a doctor, is that correct?
Yes, sir.
And do you feel like today you have a rational understanding of what's going on here in court?
Yes, sir.
You understand who Mr. Lowe is, you understand who I am, is that correct?
Yes, sir.
And you understand who the prosecutors are?
Yes, sir.
Okay. And are you pleased with Mr. Lowe as your attorney and the work that he's done for you?
Yes, sir.
Do you feel like you've had enough time to talk to him about your case and that you understand everything that's going on in your case? You understand what you've read and you understand what you've signed. Is that true?
Yes, sir.
Is there anything that you don't understand?
No, sir.
Okay. Mr. Lowe has already indicated that he believes that Mr. West is competent to enter into this plea agreement. So, Mr. West, you are indicted with a second-degree felony offense of burglary of a habitation that does carry a range of punishment of not less than 2 years in prison or more than 20 years in prison. It carries a fine not to exceed $10,000. The plea agreement in your case, as Mr. Lowe stated, is that the state's recommending that you be convicted of that offense, that you be sentenced to 5 years in prison, but that sentence be suspended today. That you not serve that sentence at this time, that you be placed on 5 years of probation or community supervision, and that you pay restitution, that you pay court costs and reimbursement fees. And the state would be dismissing a few cases, criminal trespass cases, and a false alarm or report. Mr. West, is that your understanding of how you're going to resolve your case today?
Yes, sir.
Okay. Then understanding all of that, Mr. West, how do you plead to burglary of a habitation?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
And has anybody threatened or forced you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Lowe, any objection to the stipulation of evidence?
Oh, no, so stipulated.
All right, the court will admit that in evidence. The court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor.
Anything further from the defense, Mr. Lowe?
No, Your Honor.
All right, of course, going to review the stipulation of evidence. All right, based on the court's review of the evidence, court finds that there is sufficient evidence to convict Mr. West. Court will follow the plea agreement in this case. Court convicts Daniel Keith West of burglary of a habitation. Court assesses his punishment at 5 years confinement. Texas Department of Criminal Justice. The court will suspend that sentence today, place him on 5 years community supervision. Court will place him on the mental health caseload. That's not reflected in the court's judgment, but Ms. Burns, I would like that to be as a condition of community supervision, that he be placed on the mental health caseload. He pay restitution of $212.49. Reimbursement fees of $520, restitution of $212.49, and the court will dismiss the cases outlined in the court's judgment of conviction. Mr. West, you're hereby remained into the custody of the probation department so they can carry out the terms and conditions of the sentence. So, Mr. West, you're gonna go over, you're gonna be fingerprinted by the deputy, and then the probation officers are gonna tell you about what to do next when you get out of jail, okay? It's very important that you get over to the probation department as soon as possible and following all of your conditions so that you don't end up back in jail. Do you understand?
Yes, sir.
All right. All right, go ahead, step over there with the deputy.
Thank you.
Thank you, Mr. Wilson. All right, Mr. Manning, be ready. Mr.
Judge
Young.
Randy Young.
All right, CR 22-349, State versus Randy Leonard Young, docket call, go ahead, Mr.
Judge, Mr. Young rejects the offer made by the state and requests to be set on the jury selection docket. I've explained to him the process for what happens after he announces ready for trial, as well as what happens to the offer once he rejects it. He understands that and is willing to proceed.
Okay, and just for record purposes, what is the offer that was made and rejected by?
The last offer that we received was for 10 years TDCJ. And I believe, based on what I've seen in the indictment, as well as what I've spoken to my client, I believe the minimum that he would be exposed to if he goes to a jury trial or to a judge would be 25 years.
Okay, and you've explained to your client the potential range of punishment if there were prior convictions, enhancements that were proven up. You've indicated to him, explained to him the range of punishment that he could be susceptible to.
I have, Judge.
Okay. And he understands that, and he rejects the offer. He wants to place on the court's jury trial docket. He understands that once he does so, the court will not entertain plea bargaining after.
Judge, I've explained that to him, and he continues to assert his innocence.
Absolutely, which is his right. All right, so the court then will place Mr. Young on the court's trial docket beginning next week, July 31st. Obviously, will not be going to trial on July 31st, but they'll begin moving up the list starting on that date. So, Mr. Young, once you get to the court's top 10 cases for trial, I'll notify Mr. Manning and yourself. You will not be brought to court every jury selection docket, okay? Only when your case gets in the top 10. Okay, all right, we'll see you back the next time we get to the top 10.
Judge, I believe that concludes my business out here. May I be excused to handle Mr. Huddleston, Ms. Pentler at the courthouse?
Yes, thank you, sir.
Thank you, Judge.
All right, is Mr. Castle here or is he over there?
He's here, Your Honor.
Is he ready?
Have y'all got your plea papers?
We have one little thing where.
Okay, they're changing one thing.
Okay.
Can I interrupt you for a minute?
You already have, go ahead.
I know. Okay, on Richard Blevins. He's the one I was talking to you about that I came out here to see the other day, and he was said
Yes.
he has completed his affidavit of indigency. He lives with his mother and does some lawn care. So he qualifies for a court-appointed attorney. So can we reset him for his motion to revoke? And I will appoint him an attorney.
Yes, we'll reset to August 24th.
Okay.
Okay. And just write contested hearing on August. Right, so
Castle,
other than Mr. Castle, we're bringing over Mr. Wheeler, is that correct? And Mr. Huddleston,
and Miss Pentler.
is coming, so those are the three inmates that'll be coming to court.
Yes, sir, and that should finish us up when Mr. Castle is finished.
And Judge, we just had a change on one of the pieces of paperwork which will affect the judgment, but we can just interlineate on the agreement that, and then when the judgment comes over, it'll be, I think, corrected. You know, a clean copy, if you don't mind an interlineation on the agreement.
I don't think an interlineation on the agreement is gonna affect anything. The only thing that gets affected is TDCJ judgments that actually go down to TDCJ.
And that's all we're really waiting on, so we can put our John Hancock on this and get started then.
Okay, that'll work.
I may have another correction. The judgment, so she corrected the judgment.
Oh, at the time. Oh, great.
So we can remove that first page.
Credit, oh,
The extra 6 days made.
but you put 6 on it. We'd rather have 4 than.
Yeah, I'll trade the lead, you know.
This is a punishment of fraud.
The judgment was sitting with the extra 6 days of jail time. It's correct on the jail time, but it still says 6 years. Perfect. That's okay, thank you.
Hey, you're no go.
Your analysis cut for the course.
I know, they still haven't played, they're doing all that. Hey, you have to sacrifice.
Yours is not that bad. Okay.
No, the paperwork's not.
Okay, so this.
Mr. Castle, you ready?
We are, Your Honor.
All right, this is cause number CR 20-397, State versus Jordan Wyatt McManus. And tell me, Mr. Castle, what is the resolution going to be today?
Judge, in exchange for a plea of truth, the state is going to abandon the allegations in the application to adjudicate that reflect a new law violation.
What count is that?
It's going to be. So they're going to abandon counts 1, 2, 3, and 6.
I'm sorry. Okay, go ahead and tell me what the terms. I don't have any of this paperwork here, so I'm going by what you tell me.
Thank you, Ron. So in exchange for abandoning counts 1, 2, 3, 6, state is to recommend an adjudication in 4 years, TDC credit for time served, total of 91 days credit.
4 years TDC, 91 days credit. Valid, the bond, any fines, court costs, fees unpaid.
It looks like there was originally a $2,500 fine assessed, and $150 left in court cost.
All right, Mr. Manus. You raise your right hand. Sir, do you swear that the testimony you give before will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you lower your hand. Speak up loudly for the county. All right, Mr. Manus, you appeared before the court on April 12th, 2022. You pled guilty to the second-degree felony offense of possession of a controlled substance familiar to between 4 grams and 400 grams. Court found that there was enough evidence to convict you. The court, however, followed the plea agreement, deferred a finding of guilt, placed you on community supervision for 5 years, and assessed a $2,500 fine. As you see here on the screen, the state filed its amended motion to adjudicate or revoke in April of 2023 and alleged what appears to be 8 separate counts of violations. Have you had enough time to review that with your attorney, Mr. Castle?
Yes. Yes, Your Honor.
Do you feel like you've had enough time to talk with him about this motion and that you've had all of your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've read over today that you do not understand?
No, Your Honor.
All right, Mr. Castle, do you believe that Mr. Manus is competent in entering into this plea agreement?
I do, Your Honor.
And you've explained to him his rights that pertain to this motion?
I have, Your Honor.
All right, Mr. Manus, then this time I would ask you, how do you plead to counts 4, 5, 7, and 8? Are those counts true or not true?
True, Your Honor.
And you're telling me that those counts are true because of the things that were alleged, you in fact committed those things, is that correct?
Correct.
Has anybody threatened, forced, or pressured you to plead true to those counts?
No, Your Honor.
The court will find that the agreement of the parties is that the state has abandoned counts 1, 2, 3, and 6. Mr. Castle, is there any objection to the admission of the defendant's waiver of rights to plea of truth?
No, Your Honor.
That is admitted. Evidence in the court takes judicial notice of Mr. McManus' judicial confession. Is there anything further from the state? No, Your Honor. Anything further from the defense?
No, Your Honor.
All right, then based on the evidence before, the court finds that Mr. McManus has violated the terms and conditions of his community supervision. Court will follow the plea agreement today. Court adjudicates the guilt of Mr. McManus for possession of controlled substance category 2 greater than 4 grams less than 400 grams, a second degree felony offense. The court revokes community supervision, assesses punishment at 4 years confinement, Texas Department of Criminal Justice. Institutional Division orders him to pay the balance of his financial obligations and awards him 91 days credit towards the sentence for the time that he spent in jail on this cause. Mr. McManus is hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are released from TDC, if you've not discharged all of the financial obligations, then you'll need to report to the court's compliance office here in the courthouse and make arrangements to do so. Your failure to do so will result in the court issuing a DPS profile warrant. You understand that?
Yes, Your Honor.
All right, Mr. McManus, step over with the deputy to be ready. Good luck to you.
Thank you, Your Honor.
Thank you, Mr. Castle. Good to see you.
Thank you, Your Honor, likewise.
Your Honor, I believe that completes
All right.
our business.
Yes, I was going to ask you the same. So Mr. Either, Mr. Clintler, and I was in the wrong way over. Okay. All right. Thank you, Mr. Clint. Appreciate it.
All right, thank you.
All right, Mr. White, are you ready? We've done lap, if you'll come forward. Mr. Bass, is this your stuff right here? Can you collect all of that, so Mr. White? Mr. Bass, go ahead and move all your stuff out of the way. We're backed up a few hearings, so I'm playing catch up this morning, sorry. This is cause number CR 23-49, State versus John Mason Dunlap. This is an evidentiary hearing on Mr. White's motion. Is it motion to suppress or motion to quash?
That's motion to strike against.
Motion to strike against, okay. All right, Mr. Dunlap, you can go ahead and have a seat there. Court has the defendant's motion to strike enhancements finds that it was filed July 6th. State has received a copy of that motion.
We have, Your Honor.
State prepared, ready to go forward.
Yes, Judge.
Go ahead, Mr. White.
All right, Your Honor. Just go ahead and let you know while we're going on this. The enhancement paragraphs in the cause number CR 23-00-49 have to do with case that came out of Limestone County. And there's another one that came from Banks County. One from Limestone County, I believe, was back 2009. One from Banks County is from 2015. Have similar issues. Why we're asking for to strike the enhancements. First thing out, case from Limestone County. District General was not represented by an attorney. I had invited certain, information in case I was starting this case, to discover. And I can give you a copy of the information that I received. So there's no opposition. It's not here for a long time, but I'm talking about. Basically, where we come down to is there's violation of Article 1051, right to representation by counsel of the criminal proceeding. I've also got a copy of that runoff. What we're talking about is whenever a person goes in front of the judge representing themselves, they are required to be warned of the advantages and disadvantages of self-representation. There's been times when they've said, well, if you're coming in here pleading guilty, that doesn't matter. There's also been times when they've been said, well, if you didn't get a jail sentence, it doesn't matter. But there is a case that goes against that. It's called War versus State. It's from 1979. Citation on that is 591 Southwest 2nd, 832. And to put it broadly on this man, last name Ward, comes into a county court representing himself with no intention of starting a jury trial or trying to have a bench trial. He's just coming in here saying, I did it. I'm guilty. They did not have any situation though where they told him what were on this particular case as far as what could be happening to you in the future. They also didn't tell him just in general what can happen when you get a conviction. So the court in War versus State said that you got to tell the people what the problem is. And specifically on what I just wound up giving you on that 1-051. If you go down to G, which I think down third page, down close to the bottom, or close to the top, it comes up here and says, you got to use this form. And this form, in the statute, it says shall. It doesn't sound like that's a suggestion. Now, I think if you look in the record at Limestone, there's not any place where my client signed any waiver of an attorney. And this silent record right here cannot go, even though the court did do a mark on the front page of the judgment down at the bottom. There's nothing written. And if this particular document is not there, the statute says shall, and I can't get past it. There could be some arguments that say that, well, that would be fine and well, it just wound up bringing it up on appeal from that particular case. And I guess we're about 14 years too late for that. But a case from the U.S. Supreme Court, Baxter versus Texas, and I will go ahead and readily admit that anytime I read something from the U.S. Supreme Court, I'm wondering what am I reading? But the commentators have said that any time this violation of the Sixth Amendment can be brought up at any time. And Baxter case was whenever man in Texas was being enhanced by unrepresented felonies in Tennessee, I believe. And I don't know exactly report, but I had, he called my client just for the perfunctory thing, and she wind up having a lawyer, record says no. And the obvious question, were you admonished to the advantages or disadvantages? Of course, she's gonna say no, because stuff my client me. But if the court wants me to do that, I will, or the state wants me to do that.
It's your show. I'll let you make that call.
Well, to me, it's obvious, because I don't try to waste court's time. I can go ahead and probably address some more on this right here and come back on the second part, or do you want me to go ahead and address the Van County, because it's relatively short.
Let's go ahead and address all of it.
Okay, well, this was not an issue of whether or not we had an attorney. This was an issue of whether the waiver was valid, be able to be used for an enhancement. Well, Your Honor, I don't have a certified copy. I would be willing to go downstairs and bring you the actual file. Say, since I don't have a certified copy, is that right?
So I don't know what a certified copy would show, Judge.
I'll go get it, give me permission. I know exactly where it is, but I didn't look at this file. That's what you want to do. Well, that's not what I want to do. You can do it right here, be good.
Give it to
Well,
me.
I'll let you, for the purposes of an exhibition, I guess. You can see what the problem is. It's fairly obvious on the last page. It's not agreed to by the judge. And if you give me a note, I will go right down to the county court, docket. And I know exactly what the file is.
Well, I said, Mr. White, this is your motion. If you're wanting to offer something and you don't
I
have
don't
it,
have a problem asking the judge about it, not doing something right.
I'm just saying, if you want to offer something and you don't have it and you're asking for a recess, your recess is granted. I don't want to tell you what I do want, what I don't want. I want to let you,
I don't have a problem with that.
I want you to argue your motion the way that you see fit, because I don't want.
Well, I guess if I can have recess, I need to bring that up here to you. I will. I can be down there, back probably in 2 to 3 minutes. I'll run.
Okay. If that's, I'm not telling you you need to do that. I'm telling you that if you want to offer something, you don't have it, you need time to go get it, I'll grant you a recess. I'm not telling you I need to see it. I'm not telling you I don't need to see it. I'm not supposed to tell you what you have, what you should produce or what you shouldn't produce.
Right, you can tell me if you want it or not. Can't do that.
But I'm not gonna do that. I'm gonna let you proffer your evidence, and I'm gonna make a ruling and give them a chance to object.
Judge, I'll go down there and get it. Obviously, I can tell them that you told me to get it.
Mr. White, I'm uncomfortable here.
But otherwise, they're not going to just gonna let you stay out there.
Right, I think customarily you would ask for a certified copy, because you're not a governmental official. You don't work for the clerk's office, and you're not, I'm not the judge of that court.
Well,
So
I realize this primarily is I'm trying to get this in front of you, to see what your decision is gonna be. If I can take that, I will get it certified.
So are you ready to proceed?
Yes, Your Honor. Here's some sort of back.
All right, are you offering this exhibit?
Yeah, Your Honor.
Here, you go ahead and mark it. Mark it as what you wanted on.
Is one good enough, or do you need it to be two, because they have spelling questions?
I think you offered this, so I guess that can be one. Scurry, is there any objection? Do you want to see this?
He showed me, Your Honor.
All right, there being no objection, the defendant's exhibit one, written plea admonishments is admitted.
Your Honor, in William versus State, which is 252 Southwest Second Third, 353, also from the court of criminal appeals in 2008. Waiver of right, and this one it says waiver of right of counsel, but waiver of right waives nothing if it's not complete. We couldn't wind up coming up here, which is just any kind of document when we need to hurry. And have it expected to be standing up without your signature. That does not have signature on it. That means that that waiver is invalid. So therefore that judgment is invalid. At least for the purposes of enhancement. And as I said before, Baxter versus State says I can bring this in.
What was the side on Baxter? You said Baxter stands for the proposition that a prior judgment is not eligible or not valid for enhancement if the waiver of counsel is not
So
signed.
that's what the Supreme Court said. And I would. I will have to get that side too, Judge. I had it somewhere here. But basically, that's my first side. It's that we can't bring it up at this time. And statute says shall. And war versus state. I got a copy of that as well. I've got a copy of war versus state.
I think you gave me the side on that, 591 Southwest Second, 852.
At this point, I have.
Scurry.
Thank you, Your Honor. First of all, Judge, this is not the right time for Mr. White's motion. He is trying to challenge the state's evidence here. That's an issue that should be brought up at trial, whether that be jury trial or bench trial. Challenging the state's evidence or the sufficiency of the state's evidence is an issue at trial. It's not a proper motion at this time. For one, he has no idea what evidence we're going to support these convictions. He knows what's been provided in discovery thus far. We don't have a trial date. We have are not limited to only this evidence if this case were to proceed to trial. So this motion is premature at this time. And we are not in the right part of the proceedings, part of this process for him to be raising this motion. He hasn't even heard our evidence on to support these enhancements. So he's premature. Second, the issues that he raises, while they may be good if people are attacking the conviction, the underlying DWI convictions themselves, they are not proper issues if those underlying convictions are being used for enhancements. State versus Spence instead, 866 Southwest 2nd 815 makes it clear that even uncounseled DWI convictions that are violent convictions may be used for enhancement, purpose, for enhancement purposes. In Finstead, the court said the trial court's order quashing defendant's indictment for third driving while intoxicated on the grounds that the two previous convictions could not be used to enhance his sentence because no proper admonishment had been given about self-representation prior to pleading guilty to the prior offenses. Violation of procedure 105G was reversed because the admonishments about self-representation did not apply when an individual proceeded without counsel to the guilty plea. And that brings me, Judge, to my next point. 105.1 is not applicable. Specifically, the subsection the council points to, subsection G, says if a defendant wishes to waive the right to counsel for purposes of entering a guilty plea or proceeding to trial, the court shall advise the defendant of the nature of the charges against the defendant. And if the defendant is proceeding to trial, the dangers and disadvantages of self-representation. If the court determines that the waiver is voluntary and intelligently made, the court should provide the defendant with a statement substantially in the following form. Here, the defendant, in none of his prior, which by the way, he has 3 prior DWIs, in none of his prior DWIs did he proceed to trial. In all of them, he entered pleas of guilty, 1 without counsel and 2 with counsel. We're at the wrong point in the proceedings to be having this hearing. Just because the papers offered by Mr. White don't include a separate document of the waiver of counsel doesn't mean one does not exist. We're at the wrong point to have this hearing, and that's just one example of why. He has not yet seen the state's evidence. He does not know what we may have, what we may go find. He knows what we have. We've given him everything we got now. He does not know what we may find in order to support these convictions at trial. We're in the wrong point in the proceedings for this. According to Finstead, whether there's prior counsel or not, it's not relevant when using those convictions for enhancement purposes. Mr. White offers plea admonishments signed by the defendant, not signed by the courts, when the defendant was put on probation for the for his prior DWI in Payne County. And then Mr. White refers to the judgment. Well, those plea admonishments put him on probation. 1, there's nothing in the law that requires plea admonishments to be signed by the court. In many misdemeanor courts, there are no written plea admonishments for a judge to sign. But if there are written plea admonishments, there's no requirement in a misdemeanor case that they be signed by the court. There's only a requirement that the judgment be signed by the court. I don't know whether the judgment that day was signed by the court or not, because that's not the judgments that's referred to in the indictment in this case. The judgment that's referred to in the indictment is the judgment revoking the defendant's probation and sentencing him to 365 days. I'm sorry, is the judgment revoking his probation. The allegations in the indictment, as they are made, are good allegations returned by a grand jury. Whether or not they will be proved beyond a reasonable doubt at trial is an issue for trial. It is not an issue for today. Thank you, Judge.
You could respond. Yes, sir, go ahead.
First thing out, State versus Feinstein, that came out of Waco. War versus State came out of Texas Court of Criminal. case. This case has been followed one time in Waco, one time in Amarillo. This case has been followed a number of times, and it's from the Court of Criminal Appeals. It says, even though you got probation, even though you're pleading guilty, you still gotta go through this. And also, I believe that statute does apply, because if you read the admonishment that they say you shall have, and I don't know why, that's not easy to do. It says shall, it says if in there, if you need a court-appointed lawyer. So it contemplates people who don't need a court-appointed lawyer too. But I know what shall means, and I know what the Texas Court of Criminal Appeals means. And I believe I can wind up reading this at any time once there's a indictment brought up. I don't think I have to wait. Because if they can't prove it, we shouldn't even need it.
I think it's right. All right, court will take the arguments and the evidence under advisement. I'll review it and issue a ruling soon, and let's reset the last case for Docket call. Do you have any other pre-trial matters that need to be addressed?
Well, I filed the normal pre-trial motions to do on the pass out of court. But second.
I haven't reviewed any of the other.
But I wouldn't really expect you to until, find out. Have a trial.
All right, court will carry the other pre-trial motions to trial.
And Judge, before we leave this issue, I got a little bit confused. Mr. White gave you one judgment, but didn't offer it. Was that correct?
Actually, I don't get you, Judge.
No, I don't,
I know, the rights.
I have defendants exhibit 1, which is the written plea admonishments from Van Zandt County Court of Law, cause number 2014-711. And then that's the only exhibit that I have.
Well, Your Honor, may I enter that as the exhibit number 2,
Which
the limestone county.
go here and make sure that everything that you want in that exhibit. Show what's correct.
Also going to enter in the Van Zandt County judgment is defendants 53.
No objection to either, Judge.
All right, then there being no objection, defendants exhibits 2 and 3 are admitted. All right, then we'll be adjourning this case. I'll issue we set up a good plan, so set it for docket call status. Why are you available on August?
Is that a
Tuesday.
That's Tuesday. I guess I could.
All right, Mr. Dunlap, we'll see you back on August 22nd, once you sign and get the notice of agreement. Sir. All right, do we have anyone else ready for the next contested hearing? Okay, you ready? Mr. Bass. I printed off the order. That's. All right, we're back on the record, cause number CR 23-136, State versus Michael Ray Jr. All right, and I believe where we left off, the court was inquiring counsel whether there was a condition of community supervision that was what the court would characterize as a stay away provision from the victim of the protective order case, Miss Jessica Huddleston. And I believe that the parties that come to an agreement to include an additional condition, is that correct? Shane?
That is correct, Judge. That's
Okay, go ahead and read that to the court.
That is hereby ordered not to have an with learning communication, just a house. Just a house, except as discussed.
She's got it right.
Except as specified in any order setting from the federal law case.
All right, so Mr. Huddleston, you understand that court requires that as a condition of your community supervision before I would approve this plea agreement. Understand that? That's a condition you're willing to accept?
Yes, sir.
All right, then, Mr. Huddleston, we talked about your waiver of indictment. Court finds that you have intentionally, knowingly, voluntarily waived your right to indictment, you're allowing the prosecution in this matter to proceed by information. Court finds that admonished you regarding Mr. Meaning's representation, indicated that you're very pleased with Mr. Meaning in this work. So I believe at this time, I want to make sure you understand the plea agreement, which is states recommending that the court review the evidence, if it finds that you violated, and that there's enough evidence to find that you have committed this offense, that the court defer a finding of guilt that means not convict you of the third-degree felony offense of violation of a bond order, protecting order 2 times within 12 months. That the court defer a finding of guilt, place you on 8 years community supervision, fine you $1,500, order you to pay court costs of $290, reimbursement fees of $515, and the state would dismiss several other cases as outlined in the order for adjudication. You understand that the court follows that and you violate the terms of your community supervision. The state files a motion to bring that to the court's attention. The court can conduct a hearing. The court finds that based on the evidence you violated your community supervision conditions, and the court can do several things, including convicting you of the offense, revoking your community supervision, assessing your punishment anywhere from 2 years all the way up to the maximum 10 years. So we may have talked about that before, but it's important to talk about it again. Understanding all of that, you still wish to go forward with the plea. Yes, sir. All right, Mr. Huddleston, remind me, Mr. Manning, you've explained to Mr. Huddleston his rights as they pertain to this plea agreement and both the advantages and disadvantages of the deferred adjudication. All right, Mr. Huddleston, how do you plead to violation of a bond or protective order 2 times within 12 months?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, force, or pressure you to plead guilty?
No, sir.
The court accepts the defendant's plea of guilt, remaining objection to stipulation of evidence.
no objection.
Stipulation of evidence is admitted and the court takes judicial notice of its judicial. Anything further from the state?
No, Your Honor.
Anything further from the defense? Court's going to review the stipulation. All right, court has reviewed the stipulation of the evidence, finds that there is sufficient evidence to find that there's sufficient evidence to convict Mr. Huddleston of this offense. Court will follow the plea agreement. Court hereby defers finding of guilt, places Mr. Huddleston on 8 years community supervision, orders him to pay a $1,500 fine, $290 court costs, $550 reimbursement fees. Court takes into consideration under section 1245, DA 2023-539, violation of bond and protective order, DA 2023-511, obstruction or retaliation, DA 2023-542 violation of bond and protective order. DA 2023-406 assault causes bodily injury. DA 2023-407 violation of bond and protective order. And DA 2022-1051 provision $750 less than $2,500. All right, Mr. Huddleston, before I send you over to the custody of the probation department, I want to make something very clear to you. I don't know what's going on in your life, but I know what's not going to be going on in your life. Because if I find out that you're doing anything that Jessica Huddleston that violates your terms and conditions, you're going to deal with me. You're not going to like it. Do you understand? Mr. Manning, in my opinion, is pulling a rabbit out of a hat. As I read through this, I'm wondering why in the world are we giving you a chance to be on probation? You violate order after order after order, you commit crime after crime after crime. Why are we putting you on probation? I don't know. But I'm gonna give you the chance. We're gonna say you so much as look at her wrong and it's a violation, not find out about it. All we gotta do is have a hearing. I'll take care of the rest. You understand? Serious. I don't know if you're sharing a child with this woman. You better be a co-parent, nothing more. Understand?
Yes, sir.
All right, Mr. Huddleston. You're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence and have you come forward and be fingerprinted with Deputy Martinez. Then you'll talk to the probation officer. I gotta sign all that.
It's not a mistake.
It's not last sign. They sign it after. Sign those. This one by the defendant here. The admonishments. And you ready on Spindler?
Judge, I was just made to offer that my client would like to accept, resolve, or motion. Would request, set that for a fee application. Let's go with Docket.
Thursday, August 10th.
Judge, I believe that will be. Although the court know I'm currently set number one in Buffalo County, but I believe that may or may not be going, so we'll go ahead and get it set. Coming for time, so. Probably will make
Yeah, we don't want to waste too much time now. We'd rather, it's gonna be your time, I'd rather get our tickets and go on, than us pay for her. All right, Ms. Pendler, we'll see you back on August 10th.
I believe that do no business may be excused.
Yeah, thank you, Frank. Appreciate your work. Ms. Curry, are we having a hearing, Mr. Bass, Mr. Wheeler? Mr. Bass, Mr. Wheeler, are y'all ready? Y'all come on forward. That's fine. That's fine. You can have a seat, Mr. Wheeler, right there. All right, court's going to stand in recess for a few minutes. Mr. Bass, prosecutor. All right, court calls, call number CR 23-22, State versus Jake Wheeler. I believe Mr. Bass, we were set today for an evidentiary hearing on the motion. Okay, so tell me about your evidentiary motion. Are you abandoning that motion?
We waive the motion, Judge, in case you worked out.
Okay, all right, so you asking for a plea hearing?
This
Will this be a morning plea hearing or an afternoon plea hearing?
afternoon's usually pretty good for me.
Yes, Your Honor. It'll be an afternoon plea for time guard.
Okay. All right, Mr. Bass, you got your calendar out?
Yes, sir.
As soon as I could do it, would be August 8th or 10th.
There's any way to go to, as far as the 24th, Thursday, 24th?
Yeah, we can do the 24th.
All right, great.
All right, court sets Mr. Wheeler's in and there's speaking for the court August 24th at 1:30. All right, if there's nothing further, then we'll be adjourned in that case. I think that does conclude our criminal docket for the day. Well, that is a good question. So this tapering.